Mr. Lefty? Good morning.
Good morning, Your Honor.
You may proceed.
Thank you very much. Good morning, Your Honors. Jonathan Rutley for the Commonwealth. The plain language of Chapter 90, Section 24G, does not permit a disposition that happened in this particular case of a motor vehicle homicide. It, in fact, prohibits that particular disposition. 1982, the statute was rewritten, and two subsections were delineating a felony motor vehicle homicide, including the use of alcohol and reckless behavior, and a subsection B, which dealt with negligent motor vehicle homicide or operating under the influence. And
that's what we got here, is misdemeanor.
that's
Homicide.
correct. We have a misdemeanor negligent motor vehicle homicide. That's correct. At issue in this case is the words subsection versus section. Subsection A of this particular chapter, of this particular section, prohibits, mentions the words subsection and section within Clause A or subsection A of the statute. Subsection A, the word subsection, requires that a minimum mandatory one-year sentence be instituted, and also prohibits pretrial probation or under the 276.
Isn't the answer here quite clear that the legislature in A, B, and C, they use the word subsection 3 times, and they use the word section once, and they've amended the statute recently, and they've never changed it, so they obviously meant what they said. Section means section. It doesn't mean subsection.
That is what the Commonwealth does contend. In fact, there have been several opportunities that this Act has been amended where the word section or subsection has been instituted. In fact, in the enacting clause of each one of those amendments, and including the original Act, it does use the word section, that Section 24G is hereby amended by striking out a certain subsection or striking out a certain words. So, in fact, in the enacting clause of each one of those laws or session laws, the word section is also used. In fact, this court in Commonwealth versus Gagnon in 2003 looked at two words that were used in the same subsection. They were may and shall. And may and shall were in regards to an STP hearing that the Department of Correction had to notify the district, shall notify the district attorney, and then the district attorney may file a petition within the court. And they looked at that particular subsection. This court looked at that particular subsection or section of the law and said it's very well that when the words shall and may are used within the same section of the statute, there's a presumption that the legislature realized the difference and was aware of their meanings. So what this court has seen before is when there are words used within the same section that are somewhat similar, that there is a presumption that the legislature knew what they were doing. In the second part, several times that this section has been amended, the other laws have also been added and mirrored after it. Perhaps most importantly might be the OUI motorboat or motor vehicle, vessel, which is Section 8B of Chapter 90B, which institutes very similar behavior, prohibits very similar behavior, and institutes very similar penalties. And in fact, it also numbers their particular clauses within that section, and they refer to them as paragraphs 1, 2, and 3. But also within that statute, 8B, Section 8B, the limitation is that a one-year minimum mandatory sentence is instituted on behavior that involves reckless operation, which includes alcohol, and also prohibits Chapter 276, Section 87, pretrial probation. And it doesn't just do it for Clause 1 or Paragraph 1, as it is noted in that particular section. It says section, and down below in Section 3, Paragraph 3 in that particular section, it prohibits or it institutes a license suspension for 10 years, and it actually mentions paragraph. Very similar, there are other statutes that mention section and subsection when prohibiting certain dispositions by the court. Most commonly, they're found when something is, some type of sentence is prohibited, such as a continue without a finding, or a placing on file, or requiring a minimum mandatory term be served.
Mr. Watley, could you, and it's a little convoluted, but could you address the defendant's argument that if we accept your interpretation, you get a somewhat anomalous result that if one is charged under 24GB, right, you would be ineligible for continuance without a finding, correct? That's your argument.
That's our argument.
But you could be placed on pre-trial probation for a probationary period agreed to by the Commonwealth, correct?
That is correct.
Doesn't that run absolutely counter to our decision in Commonwealth against Tim T, that you then get to the end of the probationary period and you don't have a continuance without a finding? So essentially what you have is an outright dismissal of the charge?
I think in not being familiar with that particular case, but I think what would happen if the pretrial probation was instituted for the subsection B behavior, that the Commonwealth would have to, in fact, agree to that particular sentencing. There'd have to be an agreed
that
upon.
may get over Tim T, but it's somewhat anomalous that you have this pretty serious conduct, and that at the end of that, because you can't have continued without a finding, you essentially have an outright dismissal at the end of that, don't you?
At the end of a pretrial probation?
Yeah.
Yes, you do. But that is not the behavior in this particular instance that the legislature warranted. In fact, if you took the defendant's argument that the reason for the passage of this particular law was the enhanced awareness of the carnage of operating under the influence on our roadways and the deaths that were caused, that they were trying to address that matter when they passed the statute in 1982, and they were not trying to address negligent motor vehicle homicide. In fact, if you took his argument that that was the purpose of the statute and the passage of the law, then simply operating under the influence and causing a death would also be available for a continue without a funding, in direct contradiction to his argument.
Well, I have to say, you point us to legislative history, but I don't think you've given us any legislative history. The only legislative history that I have is the defendants, which at least seems to suggest that what they had in mind was alcohol. What they were dealing with was paragraph A, which was, all of the alcohol-induced, deaths on the road, correct?
Well, both A and B deal with alcohol deaths. One is a felony that involves alcohol and reckless behavior and requires a minimum mandatory. But B also deals with alcohol and death also. It just does not have the reckless behavior.
Was there an amendment to B at the time of the 1982 amendments? No, when are they?
The 1982 amendment, subsection B, actually is fairly in line with what existed prior to the dividing of the section 24G into two subsections. Subsection G is essentially, B is what essentially existed beforehand.
It appears to me, maybe I'm wrong and we can never tell, but it appears that when they amended the statute to add subsection B, that's what they did, right?
Well, really, to add subsection A.
Subsection A.
Right, I'm sorry, they just forgot, they didn't put the sentence in the right place. The sentence should have come at the end.
Well, that's one way to interpret it. The other way is that they're adding a whole new section, and they had in mind a section.
I believe that they did have that section, and they looked to the behavior or the results of the behavior that was trying to be addressed by this section, both the new subsection and the existing subsection B, if you will, that when a death occurred, that it was not proper for a delayed dismissal after a certain period of time, that death was a result that deserved more than a continue without a finding.
But
And in fact,
the language in, let's look at the language in subsection A as added by the 1982 amendment. The last two sentences of that One is prosecutions commenced under this section shall neither be continued without a finding or placed on file. And then you have the next section, or the next sentence talking about the provisions of the probation statute should not apply. Were those both put in the 1982 amendment?
Those were
So that was
both.
part of the 1982 amendment, both those sentences side by side.
So, yes.
So that has to mean something.
It should mean exactly what is written. And in fact, they were looking at the entire section when they wrote that section, that the behavior under that section or the sentences under that section should not be continued without a finding. We don't believe, the Commonwealth would argue that it is not ambiguous at all that section means section and subsection means subsection. And as I said previously, they used both those words within subsection A, so they understood the difference between their meanings, as they did in other cases that have gone on. The Commonwealth would also...
Mr.
Yep.
Lutley, one other question. Under Section B, right, you don't have to be driving under the influence of alcohol, correct?
Under subsection B, you don't have to be, but it's an either or. You
Correct.
are either operating under or the influence, or you are negligent. So there's two types of behavior in that
Correct.
particular section, subsection. And that, in fact, is the difficulty with the defendant's argument. If you were looking at the Act as prescribing and only dealing with alcohol-related behavior and alcohol-related deaths as the purpose of the statute, then, in fact, just operating under the influence and causing a death would be eligible for a continued without a finding, which
Yeah,
is
but it is equally the case that if you don't have any alcohol, and if the legislature is focused on alcohol, and you are merely, and I don't mean that to minimize the harm, negligently operating a vehicle negligently or recklessly, which causes a death, which appears not, at least based on the legislative history that I've been given, appears not to have been the focus. So the question is, did they sweep it all in, or did they sweep half of it in?
I believe they swept it all in by that behavior because it did have alcohol in that particular section as well as negligent behavior, and they were also looking at the resulting death.
Is
as
it
a
not the case that in addition to the words, we look at where the placement of the words is, especially where you have an amendment?
This was, when you have the, you may, if you get past the statute and find it to be ambiguous, that the emplacement of the words and the words' meanings certainly might have some effect. If they were to place it at the end of subsection B, would the argument then be that it only applies to subsection B?
But they didn't place it at the end of subsection B. They didn't place it at the end of subsection C either. And I suppose you could say it because it refers to prosecutions, but they didn't place it at the end of subsection B. They placed it at the end of subsection A, and there's clearly a subsection B.
Yes, there is, and they referred to that not only in the enacting statute, that they were amending the entire section by striking it, but they also referred to the various words subsection. I bring you back to that again, the
No, I
subsection
understand
versus
that.
section.
But, and isn't it similar in the, I think it's the gun statute? There's subsections A to E, and in subsection D, it says persons convicted under this section shall not be eligible for parole or probation. And that has to mean the whole section there because there's no offense in subsection D and no sentence at all delineated in subsection D. I'm sure that's the gun statute.
That is 269, section
269, right.
10E, I believe. And it did have that particular clause. And in fact, that particular clause did have no prescribed behavior in it. It was only referring to the entire section when it was reaching back.
One could also see that the other way, which is because it didn't have any prescribed behavior, it wasn't referring only to that subsection. In fact, it couldn't have been referring to that subsection.
But I believe other parts of that statute referred to clauses within that section as clause A, B, C, and D, whereas the words in that clause referred to the entire section.
What do we make of the Tedesco Corporation case? In that case, which was a prosecution under 24GB, Mr. Gauthier was his case was continued without a finding for 3 years. Is that just an illegal sentence?
The Commonwealth would not argue that that is an illegal sentence, but that particular case, as in the several that are contained within the defendant's brief, are all agreed upon dispositions with the Commonwealth.
Well, they may be agreed upon, but if in fact prosecutions shall neither be continued without a finding nor placed on file, I mean, is that a directive both to the prosecutor and to the court? Does that make it an illegal sentence to have done such?
I would argue that it would be an illegal sentence, but in that particular case, the Commonwealth is not appealing it.
All right.
Thank you, Mr. Letley. Mr. Rappaport?
If I may just start with a comment that my brother made and was followed up by Judge Cowan with regard to the plain language of this statute. The plain language of this statute does not permit parole either. Yet in 1986, in an opinion authored by Justice Kaplan out of the Appeals Court, Commonwealth versus Haley, it was through logic and reasoning and common application of the statute, it was determined that there was a facial unclarity, I think is what Justice Kaplan called it. But frankly, the statute was construed to mean what it was intended to mean and not what it specifically said. And what this statute says is that there is no parole for a conviction under Section A. But now that has been construed judicially as being incorrect, and you can now have parole under this statute.
Is that when there is some ambiguity?
Well, when you say some ambiguity, there is no facial ambiguity with regard to what the statute says about parole. The ambiguity comes in when you look at other statutes within the Commonwealth that set out indeterminate sentences, and the purpose of indeterminate sentences being to establish a parole eligibility as well as a wrap-up date. Under those circumstances, when you bring in common sense and reasoning and other statutes within this Commonwealth, you come up with a clear indication that the legislature did not mean to preclude parole in convictions under Section A. Yet the clear language says you may not have parole under Section A. I would submit to the Court that dicta in a number of cases out of this Court and the Appeals Court indicate that there's no preclusion to quaffing a case under Section B. In Commonwealth versus Sebastian S., discussing the legislature's explicit prohibition of continuances without a finding for a variety of crimes, specifically referring to 24G, and then saying causing homicide by driving under the influence of alcohol or drugs. As Justice Cordy had mentioned in the Angelo Tedesco case, neither the Appeals Court nor this Court, in laying out the underlying facts of the case, that was a case, obviously, we didn't have the same issue, but in both the Appeals Court opinion and the SJC opinion, the driver of the defendant's vehicle, one Gauthier, was charged with motor vehicle homicide under Section B, and his case was continued without a finding. In Commonwealth versus Haley, a case I just mentioned, the Court mentions or states specifically that when the legislature enacted Chapter 373 of the Acts of 1982, it also changed the penalty for causing death while operating under the influence of alcohol and drugs. No mention whatsoever about vehicular homicide based upon simple negligence. And in fact, I would submit that under Sebastian S., it would have been very simple for this Court to have left it as vehicular homicide. But the Court specifically said that the preclusion for the continuance without a finding is when there is a conviction for causing homicide by driving under the influence. I would submit that the 24GB does not preclude continuance without a finding. I would submit, though, that if there is any question, if we have a situation where two or more reasonably well-informed people are capable of understanding the statute in two or more different ways, then the statute is ambiguous. And if the statute is ambiguous, the defendant is entitled to, under the rule of lenity, the benefit of that ambiguity. With regard to whether or not the statute can be viewed as being ambiguous, I would submit that the first thing we look to would be contemporaneous and practical applications of the statute for many years. The dicta in the Tedesco case. I've also asked this Court to take judicial notice of a number of dispositions in a number of different counties. I've included in the addendum to the brief that show that it is common practice for district courts to continue cases of this nature without a finding. I'd also ask the Court to consider various guides to practitioners. You have MCLE.
But that's interesting that you say that district courts are and I remember seeing that in your brief, the practices in some district courts to quaff these cases. Am I not correct? The Chief Justice of the District Court has said that that shouldn't be the practice.
Well, and it's very
So
interesting.
if they're doing it in the district courts, it's contrary.
Let me say this. When the Chief Justice of the District Court in, I believe, 2003 came out with this memorandum, for 21 years prior thereto, the District Court had put out a memorandum saying that it was entirely appropriate to quaff cases under Section B. When you look, and I believe the memorandum is in the Commonwealth's appendix, when you look at that, the Chief Justice says, I am now changing my opinion, which I have officially espoused for the last 21 years. There's no reasoning. There's no legal reasoning.
Well, wasn't there just a recent amendment?
No.
There was an amendment, though.
No. The last amendment to this statute, I believe, was went from a 10-year to a 15-year loss of license if convicted, if found guilty under the statute. That was the last amendment, I believe, to the statute. Prior to that was the addition of the 10-year loss of license. And I believe before that it was Chapter 376 of 1982. A day or so after the passage of the comprehensive OUI statute, there was an amendment to the Section B that put, I believe, or as opposed to and that was the only change. There have been no other changes to this statute.
So what do we do with this language? It's all enacted at the same time, so it's not like somebody added something after the fact, and maybe the last two sentences, prosecutions under this section shall not be continued without a finding. Prosecution and the provision of 87
do not apply to this
do not apply to this subsection.
Which means that it does apply to subsection B. If it does apply to subsection B, then we come to Justice Marshall's problem with, isn't this an anomalous result? In other words, you cannot have a continuance without a finding under subsection B. The Commonwealth says it's illegal. It doesn't matter if it's agreed to by the Commonwealth or not. It's illegal. Yet you can have this legal disposition, if the Commonwealth so agrees, under 276-87, which wouldn't have any of the protections for the Commonwealth and for the people of the Commonwealth that a continuance without a finding would have. That is, there would be an admission to sufficient facts. There's a finding. If during the course of a long probation, and in this case, for instance, the probation was contemplated to be 5 years. In many of these cases, as you'll see, the probations are contemplated to be very long probations. If at the end of the 276-87 period, the defendant does something to violate the terms of his probation, 4.5 years later, you're going to retry this person with stale evidence?
Well, that's an interesting policy. That's an interesting policy argument, but what about the language, side by side? This section, this subsection. Something applies to this section, something applies to this subsection. You mean it's just same? It means the same thing?
Well,
you're arguing policy. How could the legislature have decided as a matter of policy, blah, blah, blah?
I don't think I am arguing policy. What I'm arguing is the law. Under the law, you could have this anomalous result where you may have a 276-87 disposition under B, but you may not have a continuous without a finding, which in policy would be wrong. I mean, it just doesn't.
And if that's a problem, then the legislature
court
should fix it. That's where you go to fix it, not here.
May I say just this?
Well, what's the anomaly? If the Commonwealth wants to take the case to trial, presumably it thinks that it has a triable case. If they win the case, there cannot be a continuance without a finding. If the Commonwealth thinks it has a dog of a case, it can do the 276-87.
But in other words, you're saying that although it's illegal to do,
it's not illegal to do.
Well, that's what the Commonwealth, Your Honor. Clearly, in the Commonwealth's brief, they state that whether the Commonwealth had appealed this particular decision by the trial court or not, it would have been illegal. That's the Commonwealth's position.
Right,
It's illegal.
continuance without a finding is an illegal sentence under A and B. That is their position.
That's their position. So how can this anomalous result, as I say, the 276-87 disposition, how can you allow that to, and that has happened, and I've shown in my brief, just in this past 6-month period in the Somerville District Court, because there may have been a concern that the illegality of the quaff, the court, certainly with the Commonwealth agreeing, and the facts of the case often dictate what goes on in a case, but they did a 276-87 disposition because of fear that it was illegal to do a quaff, but the way the statute's written, it's not illegal to do the 276-87. That makes no sense whatsoever, Your Honor. That makes absolutely, it's illogical. Not only...
But that's based on the Commonwealth's interpretation of the statute.
Well, we're here because the Commonwealth says it was illegal what the judge did. Whether or not they appeal, if it's legal what the judge did, that's fine, and if it's illegal, that's why we're here. The court should understand that there have been a number of analogies to the gun statutes. When the gun statute was first passed in 74, making for the mandatory 1-year sentence, look at the language. Until 1990, it was the exact same language that you have in this statute. That is, prosecutions brought under this section may not be continued without a finding. Prosecutions brought under this subsection may not be placed on pretrial probation. What I submit to you is that very same language, nobody in this court or the appeals court ever considered that you couldn't quaff a case under Section B for merely possessing ammunition. In fact, I think there's a position, the statute says that on a second offense you may not quaff it. I believe that's in Section B. What I'm saying is the very same language for 16 years was interpreted by this court as precluding a continuance without a finding under Section A of 269-10, but not precluding a continuance without a finding under Section B, mere possession of a weapon. The voting statute that's been raised here, very interestingly, does not have the same language because it's consistent when it says section and section. It doesn't say section and subsection as it does here.
Could I just ask you to take
Sure.
a look at, and again, we'll have to go and look at it, and I take it that, and I'm not asking you to say whether you misrepresented, but one of the most telling pieces, it seems to me that the House bill and amended, the changes, it's very interesting to see what's going on. Now, of course, the title isn't always, but Section 4, according to you, says identifying the changes, GLC 90, Section 24G, regarding the no continuance without a finding limitation found in 24GA, that's on page 24.
Yes, I see.
Whose language is
That's
that?
mine.
Okay.
Well, it's the only place it's found is in GA. It's not found in GB.
Okay.
And frankly, I think that may be it's certainly the way in which I've placed it in the brief, but I don't believe that's specifically my language. But I would have to go back to my notes to see whether or not it's a quote or a paraphrase. But if we do look, I know that in the Commonwealth's brief they suggest that, well, inferentially we can try to figure out what the intent of the legislature was in passing the statute. And I would submit to the Court that you look at the original statute for vehicular homicide, an act imposing certain penalties for causing death as a result of improper operation of a motor vehicle. And they talk about operating under the influence, they talk about reckless operation, they talk about negligent operation. It includes everything. That's in the original 1976 legislation. In 1982, what we have is an act increasing the penalties for operating under the influence. And then we have the emergency preamble, which specifically states what the purpose of the act is, to provide an immediate increase in penalties of operating motor vehicles under the influence of alcohol and drugs. It is absolutely silent as to vehicular homicide. And I submit to you that when you have legislation that changes a statute, if they meant to change the negligent vehicular homicide in any way, they would have so stated. It was simple enough to state.
But the negligent homicide statute includes operating under the influence.
But it's
causing
an
a-
Yes, but Judge, and here's what I'm going to ask you, and I did ask this question in my brief. It's operating under causing death.
Right.
If you don't operate negligently and you don't operate recklessly, how can you be the cause of a death merely because you've had something to drink? Now I understand there's another problem with the statute, but I want to know if anybody in this court, because I've been trying to find the answer to this question since I started writing this brief, if anybody can tell me how, if the way you operate the vehicle is not a factor.
It's curious.
It's more than curious, Judge. This is not the best piece of legislation that's ever been drafted.
It's a shock.
Thank you, Mr. Lappaport.
You're very welcome.